Welcome back to Legal Briefs. We are in week number 2 of the trial for Derek Chauvin. So for today's show, I had another attorney on and we discussed the trial, the different charges, and various different legal issues that we see that we thought would be interesting to talk about. So here's the discussion I had, and I hope you enjoy it. So thank you, Robert Cummings, attorney in Salt Lake City, criminal defense attorney, for sitting down with me and talking through the Derek Chauvin trial. We're in week number 2. Lots of things to talk about, but I think one of the main things people are talking about is causation, because that's really going to come down to, did he cause the death, the legal definition of causation. We have arguments that the cause of death was because of the knee on the neck, of course. Then we also have evidence of drugs being in George Floyd's system, as well as, I think, a heart condition. So, the legal definition of causation and how the judge will instruct the jury is going to be critical to what the jury decides with respect to the different charges. As far as causation goes, Robert, just generally, when you look at causation, what are some of the different factors that come into your mind with this particular case with causation? Let's say you're the prosecution. Generally, what do you want the jury to be thinking about causation if you are a prosecutor on this case?
Well, I think the two things that come to mind for me are going to be generally the sequencing of the events. If I'm the prosecution, that you have a short time frame, the 8 to 11 minutes or whatever, with the knee on the neck, and then he passed away thereafter. And so just from a logical standpoint, that sequencing of events in a short window is going to be big for the prosecution. And then the second piece of it, whenever you have issues such as medical conditions, heart conditions, what have you, you're going to have expert testimony that comes in to try to connect the links in the chains there, depending upon which side hires the expert. So if you're the defense expert, you're going to be wanting to remove links and show that there's a disconnect between Chauvin's conduct and what ultimately caused George Floyd's death. If you're the prosecution, you want to make sure that all those links are there, connecting the knee on the neck and Chauvin's conduct to the ultimate death that occurred thereafter with George Floyd. And so that expert testimony is going to be the second bucket for me if I'm the prosecution, showing that the heart condition, drug overdose were not necessarily unrelated, but for the knee on the neck for the period of time and Chauvin's conduct overall, George Floyd wouldn't have died.
Right. Yeah. And I think that but-for causation that we hear people talking about, like in the beginning of this trial, the prosecution was, they specifically said, I don't know if it was their opening statement or later, but, after watching that video, the 9-minute video, which is just horrific, they had said to the jury, trust your eyes, trust what you're seeing. And to me, that translation is, but for the knee on the neck, George Floyd would still be alive. So trusting your eyes, just looking at what you're seeing, but for that event, of course, he would still be alive, which, that ties into that but for. But in the criminal...
I have to be careful here. But for is a loaded legal term. In the civil realm, when you're talking about negligence, you have but for causation, which is any link in the chain leading to what happened here, death. And then you have legal causation or proximate cause, which means closer in time and connection, and that whatever happened, it was a reasonable likelihood that the outcome would be whatever the harm is. So it's not the but for that I use here is more colloquial in a sense, but yes, if Chauvin didn't act that way and put his knee on George Floyd's neck, would George Floyd have had a heart attack or died of an overdose? It's a very simple way for the prosecution to have the jury look at it. And then they have the video as well, which is compelling evidence.
Yeah. Now in a criminal case, like that was the next thing I was going to talk about was But for seems to be more in the civil realm, but in a criminal case, it's not really a but for test. Isn't it going to be a little bit more complicated than that on what legal causation ends up being defined as for each one of these criminal charges?
Yeah. So one of the last fights before you get to the jury in any jury trial case, but specifically in this case, is going to be a fight over the jury instructions. And what those are is, before they hear testimony, they're going to get the opening set of the jury instructions, which says, this is the defendant, this is what evidence is. You're going to hear objections and my response to it as the judge, and instruct the jury on kind of what's going to happen. And then on the back end, you'll get the last charging instructions, which say, this is what you need to do. And they can be, maybe 5, 10 questions or instructions, or they can be much longer. And they're broken out into discrete parts. So you'll have, this is murder, these are the elements, but then let me tell you what each of those elements means. And here specifically, we have that exact fight going on between the defense and the state. And a lot of times the jury instructions are going to be the same. Each state can have model jury instructions where a panel puts out instructions that essentially tell a court these are acceptable based upon the law for what you're trying to instruct a jury about. But there can also be fights over the nuances between cases. And we have one of those fights here on causation. I'm not going to read the whole instruction. It's a bunch of legalese, rather dense, which the jury is going to parse through. And my experience is the jury is going to look very closely at that and understand what it is. But at the end, there's a discussion of superseding cause, which I think is where the fight's going to be here. The defense is going to say the superseding cause was the overdose or heart condition. And in the defense instruction, they actually have a statement that says an overdose or heart failure that causes death is a superseding intervening cause. And then the state's instructions, the last sentence says, an action that occurs before the defendant's conduct and is not the sole cause of the death does not constitute a superseding cause. So that essentially telegraphs the two cases here. George Floyd had these conditions beforehand. He had a heart condition. He had used drugs. You look at the state's last sentence, and it says if that was there before, that's not a superseding cause. And then you look at the defendant's suggested last statement, and it's an express statement, which I think is problematic for the defense. But if an overdose or heart failure causes the death, then that is a superseding intervening cause, severing causation, and therefore allowing for a pathway to an acquittal for Chauvin.
Okay, maybe now would be a good time to actually look at the different charges, and then we can talk more about that jury instruction, the competing jury instructions in the context of the different charges that we have. Like we have the manslaughter in the second degree. Maybe I'll try to pull that up. If we can put that up on the screen while I read that, I will. But we have manslaughter in the second degree. Let me find that language. I think this is Minnesota statutes. It's 609.2051. Let's see. By the person's culpable negligence, whereby the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. All right. So, I mean, we've got culpable negligence that we're going to be talking about, and then creating an unreasonable risk of death. I mean, just from reading that statute, to me, it seems like that fits pretty well with the situation that we've seen on the video. I mean, it seems to me like that one fits really well. I don't know, Robert, your thoughts on that on this manslaughter, second degree manslaughter charge, but that seems to fit pretty well with my reading of that.
Well, we can go through a little exercise here. I don't want to bore anybody. If you Google Minnesota docket and you have the Chauvin case number, you can pull up all the source materials, which is what we did earlier today. But the jury instructions, I'm looking at the defendants here, and it says culpable negligence is intentional conduct that the defendant may not have intended to be harmful but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. So the intentional conduct there is that I don't think anyone can dispute that Chauvin intentionally placed his knee on George Floyd's neck. That's the intentional conduct. The question is that whether an ordinary and reasonably prudent person would recognize that doing that would cause injury to George Floyd. And if you go on in the definition, it says that the conscious disregard of a substantial and unjustifiable risk of which one is actually aware, and not a disregarding of a risk of which one should be aware. And that's where the fight is over there. Was it such a gross action for him to do, and so likely that death would result, that the jury can convict him? And I think if I'm the defense, I think Chauvin has a tough time here, because I believe that there have been officers that testified this is outside of their training protocol. So they can't cite that this is something that he's told to do and it's ordinary in the line of his work, and that if he's trained that way, then they're on almost by definition cannot be an unjustifiable risk. But at the same time, if I'm the defense attorney, I focus on this is simply a knee on the neck. And I know I'm minimizing here, but that's what the defense attorney has to do. If you're kneeling on somebody's neck and he's still able to talk, he's still able, to ask, to say, "Mama, please help me," and even say, "I can't breathe," that's what I'm going to hammer on if I'm the defense. Would an ordinary, reasonably prudent person, even if you think that placing a knee on somebody's neck is horrible and atrocious and disgusting behavior in a civilized society, would an ordinary and reasonably prudent person believe that death is going to result, or that posed a substantial and unjustifiable risk when I can still hear him talking and breathing? So that's what I would do, just kind of shooting from the hip here if I'm the defense attorney.
Yeah, now something you said earlier I wanted to touch on, that protocol where you put someone on the ground and you put a knee on their neck. It was my understanding that particular practice is something that policemen have been trained in, and they have done many, many times before. But I believe it is the extended period of time with which he was doing it. At some point, that is where people are saying that it became unreasonable when, he clearly was having issues breathing and it was turning colors. Like, clearly something's really, really wrong here. I think they said some people were saying he was looking purple, like what's going on here? That although the initial act of doing it may have been in policeman's training manual or procedures, continuing to do it for 9 minutes, at some point along there, it became an unreasonable act. And when you mentioned that earlier, was that your understanding of that particular procedure, or did you have a different take on that?
No, and I think it's important to note here that those in the courtroom are seeing the testimony, they're assessing the presentation of the witnesses, assessing their credibility. And so I'm not going to watch 2 weeks of trial remotely. I wish I could, and I was a talking head on CNN. It would be a fun job. This is just simply picking up, little nuggets over the past couple of weeks and what I've heard has been presented. But if, as you presented it, is in the record, then I think it makes the state's job more difficult, because you're parsing on a timeline that at some point it was arguably reasonable based on his training. And as such, if an officer is trained to do that, then it can't be a substantial and unjustifiable risk. But then at some point it switches over to then being a substantial and unjustifiable risk in the same sequencing of events. So the prosecutor, again, is going to kind of narrow in and say, this is one sequence of events. It's a short time period. And the defense, I think, is going to parse it out more. Prosecution is going to narrow it down and then probably have to kind of parse it out and say, this is the line. This is where there was enough other factors. If it isn't the evidence that, his face was turning purple, if his voice started getting garbled, if he was, whatever the body reactions are to suffocating, If that evidence gets in the record, that's where the prosecution is going to focus, and the defense attorney is going to say, no, you're having to cut it too thin here. If it was substantial and justified at the outset, you can't say that at some point it switched over and then all of a sudden became unjustified. And I'm not saying either's right or wrong. The attorneys put on the hat of whoever party they're representing, the state or the defendant, and they put on their best case. And it's for the jury to decide, which one makes sense to them based upon the instructions from the judge. So,
all right, let's go to another charge that they're making against Derek Chauvin, which is the murder in the third degree. I'm going to read this right from the Minnesota statute again, 609.195. Whoever without intent to effect the death of any person causes the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life is guilty of murder in the third degree. Can be sentenced not more than 25 years. So here we've got, there's no intent. So we've got without intent here. The one thing I should clarify or at least talk about is this murder in the third degree. This was the charge that the district court judge had said, no, you can't make that charge here. They appealed it. An appeals court in Minnesota actually said, yes, you can. And so this is the charge that was added back in. And I think it had to do with the fact that it says that eminently perpetrating an act that's eminently dangerous to others. And I think the district court judge was thinking that others means others besides George Floyd, the victim. And I believe the appeals court said, no, others includes him. So add that charge back in. I know there's a number of legal commentators out there who kind of don't think this makes sense, this murder in the third degree, because of the language about two others. Anyway, I just thought I'd throw that in there since it was an issue, and that's how it got added back in. But this is a depraved mind, dangerous to others. But there's no intent. So this murder in the third degree, any thoughts about that with the Chauvin situation?
So to me, when I'm looking at these situations, I take a step back and go back to first principles, so that we have a homicide here, which is the taking of a life, essentially, by another. And then you can parse it down and split it depending upon, as you've brought up, intent, specific intent, general intent, knowledge, recklessness, various state of minds. And then there's been an expansion over the past how many hundreds of years to include more in felony murder, which is another charge here. If you're committing a felony, a violent felony, and a death happens, you can be charged for murder. This kind of seems along those same lines, that you didn't intend to kill somebody, but you acted in such a way that is eminently dangerous and with a depraved mind without a regard for human life, and the person died. So it could be an assault, it could be myriad of other crimes, but they lumped it into a murder charge as well. Again, I think the difficulty in this case, candidly, is that he's an officer, and it's an eminently, difficult job. It's a violent job, and based upon their training, can you say that the act that he engaged in was eminently dangerous, and was he evincing a depraved mind? I don't know. I haven't passed judgment on that, and I'm happy I'm not the jury in this case. But again, that's where the fight's going to come down to, based upon the particulars of the case, parsing it all out, and each side picking up, their best nuggets from the evidence and creating the narrative, with the defendant saying, you cannot say beyond a reasonable doubt that Chauvin acted with a depraved mind, or that him placing the knee on the neck was eminently dangerous. It's not just dangerous. There's an adjective there, an exacerbated level of dangerousness. So can he be convicted? Yeah. If the jury hears the evidence and thinks that the elements are met under the jury instructions, is there a chance for an acquittal? Absolutely.
Let's go to the last charge that we're going to talk about, murder in the second degree. So this is Minnesota statute 609.19, subsection 2, under 1. causes the death of a human being without intent to affect the death of any person while committing or attempting to commit a felony offense. So this looks like this is the Minnesota felony murder statute. They have without intent, but in the process of committing a felony. Now it's my understanding. I think this one, from my understanding, I think this one will be a tough one to get, because it's my understanding that the felony has to be an independent act, like separate and apart from the actual act that caused the death. Like they were robbing a bank, and in the middle of robbing a bank, someone got shot and killed accidentally. I don't know. So felony murder applies because they were committing a felony of robbing the bank, and during that happening, somebody happened to die. This one, I wanted to get your thoughts on that, because it doesn't seem to me that there's a separate act. It was like he put him on the ground, he put his knee on his neck, he did that for 9 minutes, he died. But the separate felony, there's not really a separate felony, unless I'm misunderstanding how that works. But that's always been my understanding of how the felony murder rule applies, is it has to be a separate act.
So you mentioned the word, the operative word here or phrase, which is matter of law. So there's issues in a court that are matters of law for the judge to decide. And then there's issues of fact that are submitted to the jury for them to decide. And the one issue here of law that comes up with the felony murder, what you just described, I believe it implicates possibly other things too, but it's the merger doctrine. If somebody was charged with 2 crimes, and the lesser crime, proving all those elements, is necessary to prove the greater crime, then the 2 crimes merge. In order to avoid that, you have to show that the elements are distinct in some form or fashion. So you'll see like federal criminal indictments where somebody is charged with 20 counts based upon the same sale of meth. And the way that the prosecutors get away from that or avoid merger is there's just little nuances, separate distinctions with each count and with each element. But that's an issue of law. So it's going to the jury. It appears from what I've seen, that count's going to go to the jury at the close of evidence. And if they did believe that as a matter of law, the underlying assault that ultimately caused the death cannot justify felony murder as well, they probably would have filed a motion to dismiss like they did on the other count as well to get that out and not have it go to the jury. Now, they could have strategically left it in because it is the highest count that they're going for. I believe it's the 2nd degree. And they could be using that, to the jury to say that the prosecution is overcharging here. So it could have remained in as a strategic decision. But I can't definitively say that if somebody commits an assault and the death occurs therefrom, that felony murder doesn't account because the underlying assault is actually what caused the death as well. There's a causal link there, which makes it seem like it walks and talks like traditional murder or manslaughter. There's not the distinction and that fiction the felony murder relies upon, that somebody else committed a murder while you were committing a felony as well. And by definition, it is foreseeable when committing a violent felony that somebody can die. And that's why everybody in the conspiracy or aiding and abetting the felony can be tagged with felony murder. The problem that I see here, along with those that you highlighted, and they might be true, we'd have to look under Minnesota law and review the merger doctrine and some other aspects, but it's the assault in the 3rd degree. And you can go down the state's instructions and they provide definitions of assault. And if I'm a defense attorney here, a lot of what police do when they're detaining a suspect is technically assault. They're placing the hands on another intentionally, and some things that they do depending upon how the suspect is reacting can cause great bodily harm. And that's what Chauvin was doing, was detaining George Floyd, if you want to say it in vanilla terms. So as a defense attorney, I'm hammering on that and saying that we do not meet the elements of assault. Assault is not satisfied here. Ipso facto, there's no felony murder.
So in this case, we've got those 3 different charges that we've just gone over. Murder in the 2nd degree, murder in the 3rd degree, and then we've got manslaughter in the 2nd degree. I mean, what's your opinion on whether the prosecution overcharged here? Did they overcharge, or do you think that was a good strategy for the prosecution to give the jury, okay, they've got three choices here. So maybe there might be some, I don't know, compromise. If we've got, some people in the jury who are willing to go, so far, but not farther. And maybe there's going to be some compromising back with the jury to come up with one of these that's kind of middle ground. I don't know. What do you think the prosecution's strategy was in having the three different counts here, the three different charges?
That's hard to say. Charging decisions are very tough for prosecutors, especially in these type of cases, because they know it's going to get national attention. They want to make sure that they have something that they can prove at trial, that they can convince a jury on. They obviously didn't do first degree premeditated murder, but they might have been concerned. I don't know if Minnesota's attorney general is elected or appointed, but if it is generally a political position, and they probably considered that they didn't want to appear too soft and solely go on manslaughter. But at the same time, they might recognize that they might not be able to get murder in the second degree on the felony murder, but it gives the jury three options. They can hammer on felony murder, the assault, all those components with the evidence, and tell a compelling, very emotional story about the death of George Floyd, and then fall back to it and say, look, if you don't find felony murder here, then we have third degree murder, and obviously the evidence fits the elements for these reasons. And then finally, at a minimum, there was a death here that did not need to happen, and based upon the instructions for manslaughter, give the jury that out. Because I think the prosecutor knows, if you talk to any prosecutor, they absolutely hate prosecuting police officers, because police officers are their witnesses on cases. They work hand in glove. A lot of times they share a building, which is usually right next to the courthouse, to every defense attorney's frustration. But they have to work closely. And so prosecutors do not like going after police officers. So I'm pretty certain that there was a lot of analysis that went into what to charge Chauvin with and what they think they could prove from the outset to a reasonable degree of certainty, while addressing the political wins as well.
That brings me to another point. You talked about whether the attorney general was he appointed? Is this political? As far as the amount of public pressure right now on this case, the prosecution, and also the jury. I mean, the jury is anonymous, and they're anonymous because I think they, the court was probably wanted to do whatever they could to make sure they would be safe. Mm-hmm. And if they were to give I don't know, even if they came out and said, look, we think he's guilty of manslaughter and nothing more, there's probably going to be a huge public outcry. The amount of pressure on this jury, I'm just wondering, kind of thinking out loud, how hard is it for them to make sure that we're giving someone a fair trial, looking at the elements that are in each crime, and really analyzing the facts, and not thinking about all the stuff going on outside of the courtroom, or what's going to happen to our city if we don't come out with a verdict that the public is happy with. I don't know. I would hate to be in that situation. I think that's a really tough spot for them to be in. Anyway, any thoughts on that particular point?
So to me, when people are putting a lot of focus on this trial with Chauvin and making it more than simply the question of whether the government can take Chauvin's liberty, it does a huge disservice. We have the Seventh Amendment in our Constitution, which gives you the right to trial by jury of your peers. And that is in there because it is a check on government tyranny. The government cannot put you in a cement box and take away your liberty unless they have sufficient evidence that they present to a jury of your peers that convinces them beyond a reasonable doubt that you committed the crime as alleged. We need people to serve on juries. It is a crucial function of our government. And when there's these outside pressures and concerns, there's talk about with O.J. Simpson that jury was reacting to the Rodney King situation and not assessing the evidence before them. Honestly, that's the jury's province. You can decide what you want to weigh and what evidence you want to consider. One of the instructions that I'm sure the judge will provide them is that you only consider the evidence presented in trial. You don't read any newspapers, periodicals, online material while the case goes on, because the evidence that's submitted has been vetted by the parties in the court. It's what is relevant, and this is what you need to base it on. So hopefully they're not looking at newspapers and what have you. But honestly, if there's any backlash against the jury, regardless of what their verdict is, we're worse off as a country. And we all should be appreciative that the case was filed against Chauvin. We should all be appreciative that he has a right to have a defense attorney give him a full-throated, vociferous defense. And we should all appreciate and respect that the state is putting on its best case to show that he was criminally liable and let the process work. And then thereafter, we can, as a society, come together and address these problems, because there are problems. We know that. And there's a lot of issues and ills, but we shouldn't make this case more than what it is. And I want to put the caveat out there that I understand that certain communities are impacted by this. And I don't want to speak on behalf of those communities. What they feel is what they feel, and they have every right to feel that. This is simply my comment about the jury trial system in general, and not specifically about what the death of George Floyd may mean for some communities out there. And that's an issue that I think we need to address as a society, is more empathy about other communities, other people. We need more listening. The final thing I'll comment is that both sides had an opportunity to vet the jury. There's a process called voir dire, VOIRDIRE, where you get asked questions of prospective jurors. You can strike them for cause if they have bias. I'm assuming that nobody on the jury has family that's police officers. Nobody on the jury has experienced police brutality in their past. They try to get a even-handed, unbiased jury to consider and weigh the evidence. And so the state had an opportunity to weigh in and find a jury that they're happy with, and the defense had the same. So hopefully that's a good jury who's going to look at the evidence and consider it. And in my experience, and most trial attorneys' experience, juries take it very seriously. They take their constitutional responsibility seriously. They look at the jury instructions. They ask questions to the court to define certain areas. They request to see certain evidence again. I'm going to be very surprised if this jury comes back on the first day with a decision. I think it's probably going to be 2-3 days of deliberation, if not more.
So if, Robert, if you were Chauvin's defense attorney, do you put him on the stand?
I cannot answer that sitting here. What I can tell you is the discussions are, one, he obviously has his constitutional right against self-incrimination, so he doesn't have to testify. And the fact that he doesn't testify, the jury is instructed that they cannot consider that when deciding guilt or innocence. But there's a couple things that come into play. And actually, as I say this out loud, I probably wouldn't have him testify. And this is because there's the video. The jury can see exactly what happened. And I think the problem for Chauvin, if he testifies, the jury's not going to be considering the 2 or 3 weeks of evidence and the totality of everything when they go back in the jury room. If he testifies, they're going to be considering whether they believe him or not. And that's it. And that's why a lot of criminal defense attorneys, the pragmatic thought behind having your client testify is that the jury trial comes down to that one single solitary issue. And you lose a lot of mobility and nimbleness in parsing the evidence during closing. You call a defendant to testify, your client to testify in more complex cases. We had our defendant testify in a healthcare fraud case so we could explain why he did certain things and why certain accounts were set up and why certain businesses were set up to humanize. Plus, we thought the jury would really like him in that case. So when the jury went back into the jury room, if they focused on whether they believed him or not, we thought it would be beneficial. But I think here, there's not much that Chauvin can add to substantive evidence. And when he says, I didn't intend to hurt George Floyd, I didn't want him to die, I was simply trying to arrest him, the jury is going to have that testimony juxtaposed with the video. And the question is, which do they believe, or what's the outcome from it? So he shouldn't testify, in my opinion.
And if he is put on the stand, then it opens him up to cross-examination. And I think they can bring in a lot of the, anything that he's done as a police officer that was excessive force. I would think that they could probably just really let him have it on the stand in cross-examination, which would be, something you'd really have to weigh on whether you want to, risk having that happen and having that's what the jury is thinking about when they go back to come out with a verdict.
Yeah, you raise an interesting point there. One is you can't have selective waiver of your Fifth Amendment. So you can't get up there and testify and then say, I invoke the Fifth Amendment for everything else. If you waive the Fifth Amendment, the prosecutor gets a chance to come after you. And in this case, you can bring in prior bad acts and what have you on cross-examination I'm going to botch this, but if the defendants or the witnesses' veracity or truthfulness is in question, or they put it in question, then you can bring in prior specific acts to impeach them. But I'm not sure exactly how much of his prior bad stuff could come in if he did testify. But if there is stuff in his record, and he's getting up there and saying, I'm an honest man, I don't want to hurt anybody, then you bring in that, 2017 file where, he gave somebody a black eye, that's probably going to be relevant and goes to him saying that he's an honest, peaceful guy. So yeah, there's a lot of risks and landmines, and the state probably has access to his, his file and any complaints or what have you, disciplinary actions. So I think you're absolutely right.
Yeah. All right. Well, we've had a great talk. I think that this final question would be, do you have a prediction for what you think is going to happen? And you don't have to make a prediction. I'm just curious if you have any predictions on what you think will happen in this case.
I'm not as close to the evidence or law here to really say what my prediction would be. I try not to go on emotion. And if I was going to pass judgment, my politics or views on society might come through. I'm just not close enough here. What I will say is that Chauvin is a police officer, and they're giving, I think, a lot more grace than most in these situations. And that is going to be a substantial hurdle for the prosecution to get over. And if there was some other regular person that did this to George Floyd, I think the conviction would be all but guaranteed. But because Chauvin was a police officer, I think it makes it much more difficult for the state to prove beyond a reasonable doubt for the jury. Can they get it? Yes. I think that he could be convicted, possibly on the third-degree murder or manslaughter. And I think the jury might hear enough that they want to get some sort of culpability. But I couldn't definitively say that the defense attorney doesn't get an acquittal here.
You brought up an interesting point that I don't think we've really hit on, but it's beyond a reasonable doubt. So, when they're deliberating and trying to decide something, it's got to be beyond a reasonable doubt. So if in their minds they're thinking, well, there was a knee on the neck causing him to not be able to breathe, but also there was this evidence about his heart conditions and the amount of drugs in his system at the time, that could cause some issues with the beyond a reasonable doubt standard. And you pretty much need just one of the jurors to, not go along with everyone else, and then you're going to have a hung jury, right? So that beyond a reasonable doubt standard, I think that will definitely be something that would be difficult to get all of the people on the jury to agree on all charges. But I don't know. Anyway, I'm glad you brought that up, because that's a great point. Is that beyond a reasonable doubt is going to be definitely a huge issue.
I'm interested to see how his defense attorney puts it in closing. I think every criminal defense attorney kind of has their own way of talking about reasonable doubt, and there's no real clear-cut definition that comes to my mind. But most people say, like, after you hear all the evidence and you sit down and process it for a second, can you sit there comfortably and say, yes, he is guilty? And when you humanize that and kind of give a description to jurors about their physiological response to the evidence and what they're doing in the juror room or the jury room, then that gives you a way to try to argue to them and carry that back with them to find reasonable doubt. And that's that story and narrative on closing is very important. And that's going to be where Chauvin's attorney does win the case. And it's by describing to them reasonable doubt, picking up those aspects of each crime, focusing on those adjectives, and then literally just poking holes. And that's where the officer component comes in, because this is what Chauvin's supposed. He's supposed to arrest people. He can use physical, or he can be physical in his job under certain circumstances. So he's authorized in many regards to do what he's being charged with here. Not specifically, but in a general objective sense. And I think that's where it gets difficult to say definitively that, yes, you're going to get a conviction here against an officer.
Right. Yeah. There's just that all he needs to do is create a reasonable doubt in the mind of, all you need is one jury member. So anyway, thank you so much, Robert, for taking time out of your schedule to go over this with me. And thank you, everybody, for watching. And we'll see you next time.